Thank you, Deputy Speaker. And I rise today to support the Australian Human Rights Commission Amendment Cost Protection Bill 2023. This bill amends the Australian Human Rights Commission Act to include cost protection provisions that will apply to unlawful discrimination proceedings commenced in federal courts. Speaker, the landmark 2020 Jenkins report found that workplace sexual harassment is prevalent and pervasive. In response to the recommendations made in that report, the government introduced the Anti-Discrimination and Human Rights Legislation Amendment, Respect at Work, Bill in 2022. Schedule 5 of that bill proposed a cost neutrality approach, sometimes referred to as a soft costs neutrality model. This approach requires that litigants bear their own costs in a case unless the court considers it just to order otherwise. It was initially felt by the government that this balanced the need for certainty and the clear impacts that costs can have on applicants taking action in the courts against the unintended consequences of cost reform, such as impacting access to legal representation. At the time, though, the Legal and Constitutional Affairs Legislation Committee noted that there were differences in opinion about these cost provisions settings. Cost neutrality models carry certain risks, which may well decrease a victim survivor's willingness to progress a claim. The harm suffered by victim survivors is recognised through the courts, primarily through compensation awards, which for sexual harassment and discrimination matters have remained persistently low. Because the overall cost of proceedings is often exacerbated by the delay tactics adopted by well-resourced respondents, and it typically ends up exceeding the assessed damages, cost neutrality models risk significantly limiting access to justice for people who have been discriminated against or harassed. Despite these concerns, that committee, the Legal and Constitutional Affairs Legislation Committee, did recommend the soft cost neutrality model in the previous iteration of this bill. At that time, I sought to amend the cost provisions model. Recommendation 25 of the Jenkins report set out the absolutely paramount need, to ensure that fear of adverse cost orders did not prevent victim survivors of workplace sexual harassment from seeking access to justice. So, I was of the view then, and I believe now, that victims of workplace sexual harassment should be able to speak out and to receive justice without fear regarding adverse cost orders. This risk can clearly act as a strong disincentive to people who wish to consider pursuing sexual harassment matters in court. So, last year, I proposed an amendment to the House of Representatives giving an alternative to that cost neutrality approach. The amendment proposed an equal access or asymmetric approach. Under this approach, each party bears its own costs, except when the applicant is successful. Where the applicant is successful, that is, where the court has found that the respondent has engaged in discriminatory conduct, then the respondent will be liable to pay the applicant's costs, as they should. This equal access cost model has a number of advantages. Firstly, it ensures that applicants are not dissuaded from bringing claims because of fear of having to bear their opponent's costs should they not succeed. Secondly, it provides protection for respondents from vexatious claims, unreasonable acts or omissions. In such instances, applicants will, reasonably, be forced to bear the cost of their actions. Thirdly, this model allows for costs to be awarded against a respondent when the applicant's case is successful. And finally, it avoids the unintended consequence of discouraging claims being brought in both class actions and individual proceedings, where the amount of an award will be significantly diminished by the costs incurred in prosecuting the case. Adoption of this asymmetric model of costs provision mirrors that already in place domestically for whistleblowers via the Public Interest Disclosure Act of 2013 and the Corporations Act of 2001. In introducing this change to the usual cost rule for those laws, the Parliament recognised that legal costs can be prohibitive to any person seeking compensation for damage, and that the risk of being ordered to pay the costs of other parties to the proceedings could well deter whistleblowers from bringing matters to court. I'd argue that complainants who litigate sexual harassment and discrimination cases are also acting in the public interest. They are also seeking to assert their rights, the preservation of which benefits us all. This case was well made in the study Damages and Costs in Sexual Harassment Litigation last year. It's also important to note that the equal access cost model can remediate, at least to some extent, the differentials in financial resources and power which might otherwise be apparent between victim survivors and respondents. The power differential in particular is very often present in claims brought pursuant to the Sexual Discrimination Act 1984 and other discrimination claims. The equal access model has obvious advantages in improving access to justice for victim survivors, practically speaking, in levelling the playing field for legal action. Speaker, my argument remains. You should not be excused from bearing costs when you have broken the law. This bill will act as an incentive to change workplace cultures that permit discriminatory treatment. This should apply not only to sex discrimination cases, but to other cases or instances of discrimination on the basis of race, of age, or physical capacity, in other words, other human rights cases. People and organisations found to have engaged in discrimination or harassment in breach of the law should have to pay the legal cost of the applicants seeking to hold them to account for their actions. The amendment I proposed last year in this place was not passed because it was at that time not supported by the Albanese government. Representatives of the Australian Greens and the Jackie Lambie Network intended at one point to introduce similar provisions to mine in the Senate, but ultimately they did not need to. Under sustained pressure from the crossbench, the government chose to remove the cross provisions from this bill and to allow further consideration of this most important issue. In one submission to that review, the Law Council Australia noted that the cost neutrality model in any form is no longer supported by a majority of practitioners in most jurisdictions. It also commented that the Law Institute of Victoria has submitted to its members report that, given the cost of litigation, it is mainly high-value claims or strategically litigated pro bono claims that are brought. It considered that an equal access model would encourage more discrimination matters in the public interest and that it would empower applicants from marginalised communities, from vulnerable backgrounds and those with low-value claims. Speaker, I thank the government for demonstrating an ability to pause and to listen to the voices of experts. These are important matters which affect the ability of our government to protect the vulnerable and to ensure access for justice for women subjected to sexual harassment in the workplace. Deputy Speaker, when I was elected to this place last year, I pledged at that time to take action to address gender inequity and to protect women in the workplace, and I am proud that this bill has come back to this House in this form. I hope that it proceeds successfully through both this and the other place, and I commend the bill to the House.